Let's see, what song should we start with this? Maybe this one. Good morning, everybody. Welcome to the weekend review. Today we're doing Judge Simpson all day long. We got a lot of reappearances and a lot of updates. 2 hours of Simpson ahead. Get your coffee, get your tea, grab some crumpets, maybe hug your dog, run from your cat, get ready. Because Lone Wolf is on, is where it's at. You know, Phil, whatever the Pope drinks technically is holy. Oh my. It looks like it's noon. 11 a.m. Central Time. Noon Eastern Time. You know what that means? That means Lone Wolf Usul is live online and the weekend case review is underway. Ladies and gentlemen, we have a huge show today. It's 2 hours. So, you know, actually it's a little north of 2 hours. Not a lot, but it is north of 2 hours, and it is all Judge Simpson. We're going to see a lot of reappearances today. Just about everything you're going to see today came from the October 31st, the Halloween docket. I excised pieces of that docket and put those pieces together with some recaps, just so people who might not have seen the earlier cases will get an understanding of what a lot of us have already seen. And in some of these cases, some of these incidents have been going on for so long that, I mean, even me, after I've seen the stuff a couple of times, it helps just to have a recap. So I have thrown some recaps in on these episodes. I hope everybody enjoys all that. And since it's 11 o'clock and we got 2 hours of show, I'm just going to go ahead and get it started. And we're starting that right now.
Court does call the case of People State of Michigan versus Peter Heenan.
Nicole, you on behalf of the people.
Right here. Nope. No, other side. There you go. Short counsel.
Good afternoon, Judge. Jackie Mossboard, and on behalf of Mr. Heenan, who is present to my right.
And John Shea, Your Honor.
All right. Okay. Mr. Heenan, and the record should reflect just briefly set it out that while we were waiting for the courtroom change, I had a bench conference with counsel, and given those discussions, Mr. Heenan was, prior to calling his case, sent over to Community Corrections to obtain a scram tether and also to take a full panel drug test. Went over, did that, came back a 0.10 on a PBT, could not have the scram tether put on because of that. And also came back in terms of his drug testing with a possible dilution in terms of the creatinine level. Came back positive for benzos, and came back for positives on the benzos. Mr. Heenan, let me ask you this. You blew a 1-0. When did you stop drinking? When's the last time you had a drink?
So about 4, I woke up and my hands were shaking. So I drank some high noon. And then at
How much high noon did you have?
just enough till my hands stopped shaking.
Okay, what's that? Tell me what that means.
Like for me, it's like 4 to 6. And then at 7 this morning, when the liquor stores open, I had a DoorDash delivery of more high noon. And I drank again until my hands stopped shaking.
And how much did you have that time?
Your Honor, honestly, I just kept drinking until my hands stopped shaking. It was a 4-pack.
Okay, it was a 4-pack.
High noon comes in 4-pack.
Right. And so did you drink them all?
Oh yeah,
Okay. And how long did that take you?
I chugged.
Okay, so that DoorDash delivery at 7, that was the last you had?
Yes, and my hands were shaking, so I've got a bunch of empties, and I this is how desperate I was. I would pick up all the empties on my table and see if there were sips. And there was one that was like that full, and I chugged that as well.
Do you think you're in trouble? I mean, just not with the court. I'm not talking about with the court, but just with you and your sobriety.
I do. I have 16 years of sobriety. So I know I can do it. I'm just having a hard time right now with this divorce and losing the kids. And just life is hard right now. You know, I had to resign my job I loved. It's just been rough.
Okay, so right now you're also not working.
I had to resign to go to treatment.
I'm just gonna let you know that you're gonna be staying at the Washington County Jail. Temporarily revoke your bond. Okay. Now, I'm not doing that necessarily as a punishment, but I have no way to release you and keep the community nor you safe. At this time, the bond is revoked. Just reset it tomorrow. Thank you. Court calls the case, People versus Peter Heenan.
Prosecuting attorney, Rosebud, on behalf of people.
Good morning, Your Honor. Jackie Moss on behalf of Mr. Heenan, who is approaching.
All right. How are you doing, Mr. Heenan?
Doing okay, Your Honor.
Okay. Where are we on this? Did we get any update on Bear River?
Your Honor, in regards to, pardon me, in regards to Bear River, yes, the update is Bear River can have Mr. Heenan admitted within 24 to 48 hours. However, they would require the referral from CMH. That was not able to take place yesterday because CMH said they required an order from Your Honor before.
For CMH to evaluate him.
Yes.
Here's what I'm going to do. And you're not going to like it, Mr. Heenan, but I'm making the call. You're not going anywhere. I'll sign the order. He'll get assessed on Friday. And we're going to get you up to Bear River and start this process. Mr. Heenan, how'd you get here yesterday?
I drove, Your Honor.
Yeah. And I'm letting you know that that factors into my decision because, Mr. Heenan, by the time we got to you and you didn't drink while you were here, you were a 0.10. By the time we got you over to community corrections, and you had already been here a while. It's that behavior that, and again, I'm not saying that you're a bad person, but your inability to make a proper judgment on that leads me to the conclusion that I have to keep you right where you are, get an order, get CMH to talk to you, and get you into treatment. Court does call the case, People versus Peter Heenan. Bless you, whoever that was.
Jessica Williams.
And may it please this honorable court, Michael Daniels on behalf of Mr. Heenan. Thanks. I have quite a few things going on.
Yes. Mr. Heenan, how are you, sir? State your name. All right. Okay, where are we now on this?
Your Honor, I picked him up at U of M about 2:15
Today?
today.
Okay.
I took him to his apartment so he could pack a bag. Had my eyes on him the whole time.
Yes, sir.
And you know what? You don't know me, Your Honor, and I just Miss Clanch. My plan today was to be at Comerica Park watching Terry Google pitch. And I thought about it. I said, how many times do you get to see that? But how many times do you get to try to save a life?
That's it.
And that's what we're doing. Right?
Okay, so here's what I want. I'm not gonna lock you up. I don't want to do it. I'm not gonna. You're to get enrolled, get yourself in a bed, and I want you there by tomorrow. Got it. So one thing that you learn about me, Mr. Heenan, and anybody will tell you this, if I give you my word, I'm gonna walk that walk with you, do what I can. Some things I can't do, but if I say I'm gonna do that, I'm gonna do it. If nothing else, I'm a man of my word. Because every day, Mr. Heenan, I wake up and I just hope that I get to see a miracle. Sometimes you don't even know a miracle when you see it. But what you've been on for the past couple weeks, the very fact that you walked through those doors, that's my miracle for today. I'll get it done. All right. And we'll look for the updates. Okay, you're welcome. Court calls the case of the people versus Peter Heenan.
May it please the court, Michael Nichols on behalf of Mr. Heenan by Zoom.
All right. And Mr. Heenan, can you state your name?
Peter Heenan.
All right. Okay, what do we wish to do today?
Your Honor, you last week set this for a review, probably to make sure that Peter got into Sanford Behavioral Health, which he did, and he's wrapping up his first week there.
How long is you expected to be there?
Peter, have they given you a discharge date?
They have not.
They have not as of yet. Okay. And Mr. Heenan, how's it going for you there?
It's going very well, Your Honor. I appreciate the opportunity.
All right. Why don't I do this? It's going to be at least, why don't I adjourn it out to October 31st? And then we can go from there. That's called the case of the people of the state of Michigan versus Peter Heenan. First of all, thank you, counsel. We had sent an email because I had actually issued the bench warrant based upon the previous history as well as. Have you received a copy of the report, sir?
Yes, I have, Your Honor.
All right.
So, Your Honor is obviously aware of the alleged bond violation. We would, first thing, there is a preliminary examination for the underlying charge, I believe, scheduled for the 31st. With that existing court date in mind, Your Honor, what we would like to do today is request a hearing on the bond violation, and I'd ask that Mr. Heenan's bond be continued.
Is there anything from the people? Go.
I think his bond needs to be revoked at this time. I think we have had multiple violations. We've tried a softer touch and it's not been successful. I'm concerned at this point.
If I may, Your Honor, I would like to apprise the court of what Mr. Heenan has informed me of. He has enrolled in a sober living facility, a sober living program. As a part of that program, there is a therapeutic assistant that would come into Mr. Heenan's home and be with him, monitoring him 24/7. Mr. Heenan enrolled in those services yesterday. He could give you the details, but I would say I know he spent a great expense to enroll in the program, Your Honor.
I have to say that I'm still concerned about that. I think at this point, one of the things that I'm seeing is that Mr. Heenan doesn't have much of a support system. I remember that we have talked previously about potentially doing an inpatient program where he would be inpatient somewhere where other people who have addictions are also inpatient, building a network of support there, then moving to transitional housing outside of his home where he would have an additional support network there, and then continuing with the larger support network, gradually reintegrating back to his home. At this point, I don't see that he would have any training wheels or safeguards, because what you have is someone coming into his space. That's not expanding a support network. That is equipping him for a finite amount of time until this assistant is no longer going to be able to watch over him for 24 hours, and then they cut and run. And he still has not established any type of larger support network to facilitate long-term sobriety. I don't think that that is sufficient. I understand that it's a great expense, but it doesn't to me seem to be anything more than a Band-Aid for a situation that really needs to be addressed at the root cause, which is the addiction with the lack of support system.
When do we want to do this hearing? Want to try to shoot for the 31st. I'll set it for a hearing on his bond violations. Well, as our probable cause conference is set for that date in any event. But now everything will be set, council, at 3 p.m. for the hearing on that day. Okay, Mr. Heenan, I made you a promise, right? Sometimes, because I don't like sending people to jail, particularly. I don't like locking people up, but I'm going to keep my word. Because here's the thing. If I let you walk out of here, and there is going to come a point where I don't know that we get you back. That's the reality. So at this time, we'll see everybody on the 31st, but at this time, defendant's bond is revoked. We'll have the hearing on the 31st.
Great, thank you, Your Honor.
Thank you.
Norfolk County, Washington, State of Michigan is now back in session. The Honorable Judge Simpson presiding on.
Maybe she. How are you doing, sir? Huh?
Almost there.
Almost there. It's been a day. We'd have been done an hour ago if we didn't take that break. Anyway, court does call the case. People versus Heenan.
Morgan Poisson for the people.
Jackie Moss Ford on behalf of Mr. Peter Heenan, present seat to my right.
All right. What are we doing on this today?
Your Honor, I'm going to be requesting an adjournment. I did make all efforts in order to have my necessary witnesses present. However, the community corrections agent, he was out of office before I even reached out to him, and he's not going to be back until after today. I did get indication from his staff saying he would be available for November 7th at 3 p.m. Additionally, Mr. Hayes, who is the Scram expert, was not available. He had an exact conflict at like 2:50 today for another hearing, so he was unavailable to testify today as well. He is also available for November 7th at 3 p.m.
Okay.
They have no issue appearing then. Mr. Hayes did indicate it would be best for him if he could testify over Zoom, which I know you've accommodated in the past. If not, he would just need to know, but I would be requesting that we turn this out 1 week.
All right. Any response?
Yes, thank you, Your Honor. The prosecutor's office did reach out and relay to us everything that was just stated. That being said, today is the date time that was set for the bond violation hearing, and because Mr. Heenan is in custody, I would object to an adjournment at this point.
All right. Well, there's a couple of ways that I can do this, because it seems to me, when did
I have a feeling I know what you're looking at.
did you get a copy of the letter?
The letter? Yes, I did.
October 29th?
Yes, sir.
Everybody else got it but me. Okay, good. All right. As long as everybody got it, we're okay. The thing is, I mean, the reality is I could let Mr. Heenan out. But if I let Mr. Heenan out under those same terms pending a hearing, it could be that he goes right back in after the hearing.
It May I, Your Honor?
Yes, go ahead.
May I propose adding, if Your Honor were to reinstate bond, perhaps add the condition of spoken with Mr. Heenan. He's not opposed to Vivitrol is a medication that we spoke about. I know that is a injectable medication taken monthly that is supposed to curb the help with alcohol addiction and abuse is another medication. I would ask Your Honor to consider, if Your Honor is going to reinstate bond, perhaps adding some additional conditions that may alleviate the court's concern about Mr. Heenan abstaining from alcohol.
I wouldn't have a problem with that necessarily. I mean, the antabuse I'm going to have a problem with because what that is going to require is that Mr. Heenan take it. And regrettably, not because he wouldn't want to, but I can't rely upon Mr. Heenan doing it.
So that's why I led with the injection, Your Honor.
With the injection, how soon could that be set up for him? Because just given the history of this case, I can't have any gaps. So I couldn't let him out, say it's going to be 3 days before he would see the doctor and get the injection. Has that even been broached to set up for him? Or do we know any of that?
No, Your Honor, it has not. We could, I could start making calls first thing tomorrow morning and start working on getting that set up if the court was, willing to entertain that.
Do the people have a position on that?
I don't think that letting him out at this time is appropriate because he's just gonna go home. And I understand he had a in-home sober living coach set up, but I still am circling back to the conversation that we had where we had this whole plan. He was gonna go to inpatient and then do some kind of transitional and then work on reintegrating to living independently, setting up a support network. I think that this is, to me, what this sounds like is yet another temporary solution or temporary treatment of a symptom without managing the larger issue, without managing the lack of a support network and the other issues that he has going on leading to and coexisting with the addiction. I don't feel comfortable setting him up in this way. I told counsel, I think that if he had a spot in transitional or if he had a spot in an inpatient that he didn't handpick leading towards some type of transitional, I would feel a lot more comfortable proceeding in that route. But I don't see how this is actually doing anything to work towards a long-term solution here.
I'm not, and quite frankly, I'm not sure that is really what we're looking at in terms of a long-term solution. It might be part of one, but I'm looking at trying to balance the fact that the hearing was set for today. He's in custody. I do understand the difficulties in terms of making sure that everybody can be here, but doing something in the interim between now and next week to try to resolve it. I would not be, so that I'm again clear, there would not be a gap where I would be letting him out, say today, to set up an appointment that may take place Friday or whenever, next week. I'm just not doing that, given the history of the case. I think I would allow counsel to set that up, but I would have to know what doctor would be administering it, how often it's going to be administered. I mean, I would have to know details of what's going to happen and try to limit, and I'll just put it this way. I mean, Mr. Heenan, with alcohol, you're like a hamster in a cage. Just you spend your time trying to figure out how to get out. And so we just try to be limiting as much we can as humanly possible his ability to try to do anything along those lines. So what I'm going to do is this, and certainly, counsel, I will entertain it when I see it in terms of any type of release, but I'm going to grant the adjournment to the 7th at 3 o'clock. At this time, I'm sorry, that's 11/7. And I'll set the probable cause at that same time. So at this time, what I would do though is continue his bond as is, subject to counsel getting that information to me to see if there's something else we can do in terms of release structure for Mr. Heenan.
Okay, and a question about that, Your Honor. I'll absolutely get on the making the phone calls first thing tomorrow morning regarding the doctor and the medical side of things. What is Your Honor's position in terms of would the condition also include the transitional housing or something else that I should look into as well?
Yes, I think counsel's right. What we were doing was he was to go into the program, transition into transitional housing, develop that network.
That was my recollection as well.
And continue on. He didn't do that. He gave me his reasons, and they're understandable, I guess, but it was somebody that wasn't willing to put forth the effort to make sure that happened. And then that's when we end up with this, right?
Yep.
So if counsel would look into that also, I think that would long range be helpful in terms of trying to address the issue. All right.
Yep, understood. Yeah, we'll do. I'll look into both matters and be in touch with your office as soon as I have information.
All right. Mr. Heenan, how are you doing?
Thank you, ma'am.
All right. All right. Stay with it. Never give up hope, right? All right. And we'll continue. Thank you, folks.
You know, my mic is way on the other side of the table over there. That's the Heenan update, guys. Yeah. I wish it was better news. I wish the guy could have just gone through his residential program, been an amazing success story, and we would all not be sitting here watching him going in and out of jail for various reasons. More on that case next week, it looks like. So we'll be watching out for that in the next week. The next video we have up is old Mr. Pence. I'm not sure if anybody remembers him by name, but this is the old Vietnam veteran who we had in court back in July. The judge was really kind of set aside by a lot of the facts. This gentleman has either Alzheimer's or dementia, something that affects his memory. He's got a really loving wife who appeared there in court with him. It's really a tearjerker. I threw in a healthy recap on this just so everybody could get it in their head what really went down on that during that first hearing, because that really becomes important during the hearing that we had on Halloween Day. So everybody, let's watch this video together.
Court does call the case of the people of the state of Michigan versus Jeffrey Pence.
Good afternoon, Your Honor. On behalf of Mr. Pence, who appears in custody to my right. How are you, Judge?
Oh, good.
Yeah, thank you, and good afternoon, Your Honor, and staff. Thank you for allowing me to appear via Zoom. Jonathan Owens on behalf of the people in this matter.
All right. This matter originally came up as a it was filed by the public defender initially, an emergency motion to release or change the bond. In this case, there was then, I don't know if Mr. Margolis filed one or not, but maybe not. But then a stipulation in order to amend bond came over. The court has not signed that. All of this relates to a conditional bond violation, which occurred on June 29th, I do believe at 8:35. Or I'm sorry, 18:35. In the city of Ann Arbor regarding contact and other things. So I don't know who wants to begin in terms of the stipulation. Because the court had some questions regarding the stipulation specifically. Are these townhouses, or how are the houses right next to each other?
Yes, Your Honor.
Is that
single family homes?
got it? And fundamentally, I guess the court's thing, because while I received the stipulation, I don't have much documentation to go along with that, which I had initially requested, I think, of the public defender. And then when you came in, Mr. Margolis.
I apologize. I was not aware. I have a neuropsych report, and I also have letters from the VA as well as Michigan Medicine relative to his cognitive disorders.
I'm not in terms of Mr. Penn's cognitive state. That is not an issue for the court. More an issue for the court is making sure that he can be released safely, number one, and where I don't want to set him up for further, I guess, difficulties where something happens and then he's had enough of a problem being arrested, brought in. I don't want to see that happen again. And so it's not an issue of questioning necessarily anybody's commitment to what's contained here. It's more satisfying myself that there's enough in place to stop that from occurring, because I think that probably causes much more of a stressor on Mr. Pence than anything else when this type of circumstance occurs. Most of my questions, well, one of the primary questions, I'll just say, from the police report I referenced was whether or not there are firearms in the home. And I think that has been answered by the affidavit of his wife.
There's no firearms.
No firearms at all.
No firearms at all. All right.
Never had firearms.
Got it. Okay. The daily care, I won't say care, but there's references in here that he'll be supervised around the clock. And I guess I need to be clear on how that's going to occur and what pieces are in place to make sure that happens.
Understood. So our initial, first I'll let the court know that we being the family, they're on a wait list. He is on a wait list for Brecken Village Memory Care Center.
Got it.
He is also a veteran. He's a Vietnam veteran, and I bring that up because he has resources through the VA. If we are able to obtain his release, the first person we're going to go see is we're going to take him right to the VA hospital. Is that correct?
That is correct.
VA hospital emergency to have him checked to see if he needs to be admitted. He has an appointment with his primary. He had one yesterday, but that was
Is
reset.
this Miss Sanchez Pence?
Yes.
Ma'am, I didn't mean to be you can come up to the podium.
Please.
You're
Sorry
the
about
one, you're the one that,
It's more important to hear from.
yeah. And can you state your name, please, ma'am?
My legal name is Juana Sanchez Pence.
All right. All right.
We also, so while we wait to hear, and she can let us know what the time frame is for Brecken Village. But we also have we have time respite care with the VA that's been approved for a certain number of hours per week. That I believe is going to be increased based upon our conversations with the VA.
When you're saying respite care, you mean around the clock in-home care?
Not necessarily from the VA. I wanted to be clear. I want to not give the court any false representations. We also have, because it's not 24-hour care from the VA respite people, we also have enlisted social workers as well as certain private caretakers.
Okay. I was getting to the point of this involving a neighbor. And that, and I don't know if you're aware of this, part of the reason I was concerned about a firearm is because allegedly there was a threat that he was going to get a gun and shoot.
Who?
That Mr. Pence was. Okay. I tell you that because I'm not asking these questions, or my concern doesn't sort of just come out of a vacuum.
I was not aware of that. Yes.
Yeah. Okay. And so that's one of the reasons, for example, given his circumstances, I've been kind of deliberate in trying to act because I didn't know if there were firearms. I don't, and I'm trying to place where the houses are to each other, both for the safety of the neighbor, but also for the safety of Mr. Pence, because I didn't want a circumstance where he's there, somehow is unsupervised, then the neighbor comes over, figures nobody's doing anything, and does something to him. So just so that you know, I'm sorry, ma'am, I did not know that you weren't aware that had been said and represented. And that's one of the reasons why it's kind of where it is now. Okay. You also may not have been aware, maybe again, you were or not, that I guess he was over banging on the windows of the neighbors. Okay. All right. I'm sorry that you're finding out this way. He was over banging on the windows, screaming at the neighbors. The neighbors, as I am gathering from the report, were screaming back. Mr. Pence allegedly responds that he's gonna, I think, end up shooting them up or something along those lines. Okay. And that's how we got there. Once, to be honest with you, for me, initially upon reading that, I was very concerned. Once upon getting sort of preliminary information regarding Mr. Penn's condition, both from the jail and from the public defender's office, my view of everything kind of changed. But I wanted to make sure that I was taking the proper steps and the proper things that were in place for the reasons I told you before, for his safety as well as the neighbor's safety. Let me ask you this, Ms. Pence. Is the neighbor aware of Mr. Penn's circumstances, or?
Yes, he is. Yes, he is. And I would continuously apologize when I heard my husband yelling at him due to noise. He's extremely sensitive to noise.
To noise. Okay.
And he would yell at him, "Where you have that so noisy?" And he knows, all my neighbors know, all my nearby neighbors know. And so he knows, and I would apologize. I'm sorry, his situation, the noise upsets him, and this is what he does. And I would apologize to the neighbor continuously.
And some of them, I'm sure, as our world, are more accepting than others, right? Okay, all right. So you said he was on a waiting list.
We are on a waiting list to move. We have to move. We're on a waiting list to move
You're gonna,
out of our home. We have no choice. Unfortunately, we have no choice. So we're moving, but we're on a waiting list. And so in the meantime, he's not going to go in that driveway.
let me ask you this. You have no choice because of what?
Because I don't want him to get into another altercation. I just don't want him to get into another altercation with a neighbor. And that's the reason. Every old person wants to age in their home, but that's not going to happen. I have to move him because I don't want him to get into trouble again for something that he does due to his illness.
How long have you been in your home?
I'm
How
sorry.
long have you and him been in your home?
Oh my goodness. Let me think back here. 87, 86, mid 80s, maybe 87, 85. Oh, 85. He retained numbers. I don't.
Bad memory, sir.
Amazing.
Good
Oh
memory.
my goodness.
Okay.
Oh, wow.
How long have the two of you been married?
I'm sorry.
How long have the two of you been married?
We were together for 7 years and we got legally married in 1988.
So a while.
A while, yes. We've had ups and downs.
As with all marriages, right? Just trying to think of a way to put this without you looking like a bad guy or me looking like, I don't, but I just need to know this information. If he goes home and he's at home, this one neighbor, what's your best guess as to their response? And here's the reason I'm asking. I'm not trying to say anybody's a bad person for that. I don't want him provoked to where he then responds. Did that make any sense?
I totally understand. The area where my husband can see the neighbor is only in the driveway area. We're going to stay away from the driveway area. In the backyard, there's a tall fence. They cannot see us. We cannot see them.
I did have an opportunity to speak to the neighbor and the victim of both of these matters in anticipation of the stipulation. And I kind of tried to assess him out and where he's at, and with the understanding of what we could do to try and facilitate him coming back home until such a time that he could go to Brecken, whatever the facility is. And he said that the driveway seems to be the biggest thing. He was like, can you just keep him in the home? And I said, well, there might be, obviously he's going to have to leave the home for appointments and stuff, and he goes, the driveway seems to be like the biggest catalyst. That seems to be the thing where the issues tend to arise the most often. And he said, and I'm sorry, I'm kind of forgetting. He said, I was like, well, what if you wanted to go for a walk with a caregiver or something? Just kind of thinking, I guess if you were to go out the front door and go, I can't remember if it was left or right. But there was one way that he could go and he would not have any contact, would not have to cross in front of the neighbor's house. So as long as he stayed, that direction and stayed out of the driveway, he didn't foresee that there would be any problems. I mean, obviously, I think the complainant in this matter is going to be concerned no matter what, but I talked to him about that, and I wanted to make sure that he was, understanding and as comfortable as he could be. And I think this is what he's the one that said, the driveway needs to be addressed.
But I've got some problems with that. And that is, and I these are separate driveways. So it's not like it's a shared driveway. So I guess I'm trying to figure out, and Mr. Emmons, maybe you can clarify it for me. Is it I mean, if I release Mr. Pence, what I'm concerned about is I'm not looking to restrict his use of his property. Because you know,
She had a comment.
You're right, Go, because see, I'm gonna be, I'll try not to say what I'm really thinking, but what I'm really thinking is this. There are people that have difficulties on our planet and in our society. It doesn't mean that we get to just hide them. And if we don't see them, then feel better. We just don't get to do that. I mean,
I don't disagree with the court at all.
and you know what? And I know you're not down here, Mr. Emmons, but I'm just going to say this also. I see Miss Sanchez Pens up here, and as she walked up, I'm looking at the two of them look at each other. It seems to me, and this is a feeling, I might be wrong, she just loves him more than life itself and is willing to do anything. But I'm not going to place her in a position because I know she, just based upon the conversation, feels that she should be the one responsible for it. And I get that. But Mr. Pence, if he wants to walk on his driveway and say nothing to anybody, why can't he say that? Why can't he do that? The way I read this stipulation, maybe that's my problem, is that he, and you guys correct me if I'm wrong, but the way I read this stipulation is Mr. and Mrs. Pence can't be in the driveway at all.
So that was an added part after I spoke with Mr. Emmons. And it said they can transport as long as they can go to and from.
Yeah.
Yeah. I don't actually have it right.
So here's my problem with that. My problem with that is, how long was he in the service?
Sweetheart, how long were you in the army?
How long?
He said 15 or 16 years. No,
Wasn't quite that.
no.
Okay.
Hours, actually. You were in Vietnam, yes? George, you did one or two.
It doesn't matter.
Sorry.
He's a vet. It's okay. He's a veteran. My point to all of that is,
Your Honor.
I am not going to stop somebody that fought for this country from being able to walk up and down his driveway with his wife. I asked that order is not happening. Now, if I have to place an order that he can't yell at the neighbor, that he can't do this, then fine, that's fine. But I mean, right now I'm mad that they're going to have to move out of their home. I mean, I get it, and I get people have to make their life's decisions, but you're making the decision because others can't seem to understand him. And the very fact that they have the right to file the complaint is because of people like him that went and preserved your right to be able to do it. At some point, maybe I'll step out my soapbox, but I'm just, if what he thinks, and whether it be right, wrong, or indifferent, that he wants to take, let's say it's just a romantic stroll holding hands with his wife down the driveway, well, darn it, he's going to be able to do it. I'm not going to place you in a position where you're sitting there worried that if you're not exiting right at that moment, somebody decides, that's not going to happen. If he goes out and sits on a lawn chair in the middle of the driveway and does nothing, I don't care if anybody doesn't want to see him. If he's not doing anything to anybody, it doesn't matter to me. You follow me? I just have a very different approach to that. And I don't want to see you or the people that you would have come in trying to care for him in that position that if he wants to go out for driveway and all of a sudden he decides he's not going to listen and he's just walking down his own driveway, that's not going to be a bond violation. It's not going to happen. Now, I don't know, Mr. Emmons, are you going to feel comfortable? I mean, quite frankly, I can just order it, so it doesn't really matter, but I'd rather it be a circumstance where the neighbor could understand that I'm not ordering that. I will order him to stay off of his driveway,
Of course.
but I'm not ordering him to stay off his own driveway.
Your
I
Honor.
think that the issue that we were trying to address, Your Honor, is that it seems that if the defendant becomes aware of the presence of the complainant, it almost acts as if some kind of an irresistible impulse. I can't say that I know Mr. Pence or Mr. Latotsky, the complainant in this matter. I don't know their entire situation. I happen to be the one that got the police report for the newest incident while I was on duty for the 4th of July. And so I'm the one that charged it. That brings me here. In speaking with Mr. Latotsky, that's the situation.
So is there another case?
There's a case out of there's a misdemeanor case for the window, for the door window that happened on the 29th of June.
In Ann Arbor.
Yes.
Same
Yes.
place. Yeah.
Okay.
So, that's what the idea of the driveway was, is to try and prevent that, I'm just using the terminology, but that kind of irresistible impulse so that, the victim doesn't feel like he needs to be confined to his home and there's not some kind of, issue that's going to arise. It's kind of to try and put a plug in that.
I mean, like I said, the driveway thing is out. I get everything else that's being said. Here's what I'm going to do. I'm not going to sign this step, but I'll need an order, gentlemen, that I don't mind any part of the order except really what is the last paragraph.
It was added at the 11th hour, Judge.
Okay.
I'm gonna have to blame.
Let's go back to hour 10 and take it out.
Okay.
Not doing it. What I'm gonna do is I'm gonna reduce his bond after a hearing to a $5,000 personal recognizance bond. So I'm gonna release him to you. So what I'm gonna do is I'm gonna release him on a PR. I'm gonna indicate that he's to be released to his wife. All right, only. Okay, so you're the only one that can come get him. You would be anyway, but you're the only one that can come get him. I've got this case. We'll get through this, man. Okay? And we'll do our best just to try not to make the punitive side of our criminal justice system. It doesn't need to be. That's not what this is about, as far as I'm concerned in this case. This is about just trying to get to something that's right for everybody, but certainly right for Mr. Pence, and see what we can do. Okay. Maybe, not that I'm interfering in any other case, but maybe if people want to let them pay for the window and the other thing, they can let that part of the criminal case go. I don't know what punishing with another case does, but I'm sorry, I probably shouldn't have said that out loud, but I feel it.
It's your courtroom, Your Honor.
Absolutely. What I want to say.
Court does call the case of the people versus Jeffrey Pence.
Mr. Waddle, the people.
Thank you, Judge Lawrence Margolis, on behalf of Jeffrey Pence and his caretaker wife. May she approach as well?
Yes. You want to
Mr. and Mrs. Pence, please state your name for the court.
Jeffrey Pence.
All right.
Juana Sanchez Pence.
Hello. Afternoon, Your Honor. Today's date and time set for an adjourned PCC. We had held this pending a competency evaluation, which was received yesterday. I don't know if the court had an opportunity to review it yet. Since receiving that, I have also received notice that there was a bond violation notice filed in this case, and I had also filed a motion to withdraw from the matter, but that may or may not be necessary depending on what happens today and what we do from here. And if Your Honor would like us to approach on this, I'm happy to.
Hang on.
You read the competency?
All right. I see the opinion of the. All right. So which one of these did you want to try to take first? Well, I think we have to deal with the competency issue first, quite frankly.
Yes, Your Honor. At that point, the people have received the order from the, or excuse me, the evaluation and report from the Center for Forensic Psychiatry. We have no additional evidence. We would stipulate to its submission.
Given that he's not competent to proceed, I was
with an unlikelihood that he would be restored.
Correct. I was hoping that the people would be inclined to agree to dismiss the cases.
Well,
a couple of things in our office, Your Honor. So we would be requesting that to happen. Sounds to me like defense counsel is also stipulating that report based on the representation that
of course
the defendant is not competent as well.
We would judge.
The court would find that the defendant is at this time not competent to stand trial and unlikely to gain competency within the statutory period. And upon presentation of an order to that effect, Mr. Margolis signed that order. I will set a competency review hearing. Well, set it to statutory time. Give me 90 days.
January 30th.
Set one January 30th, 2024, 25, excuse me, at 9 a.m. All right.
I just spoke with Mrs. Pence, and she has advised that she would like me to advise the court that I want to withdraw my motion to withdraw from this case. Bless you.
I'm glad, because otherwise I was going to deny it in any event.
Understood.
So,
no objection, no problem.
All right. Okay, so the other problem I think that we have then is the bond violation. I don't know if anybody wants to say anything about that to me. I mean,
if the people, I defer to Ms. Lundy initially.
Well, I'm going to let you guys say what you want to say. Then I'm going to say what I got to say.
No, I leave it in the court's discretion. The court is very familiar with the case. And
well, I guess one question I do have is out of that, is there going to be additional charges? And I know that's maybe an unfair question to ask, but part of my reason for asking that is not the hearing before, but the very first hearing. There were people trying to tell Mr. Pence that he couldn't do certain things and wanted this court's backing in saying that. I won't go through my words exactly, but I think I made it very clear that this gentleman is in part, I get to do what I get to do because he did what he did, and he's a veteran, and if he wants to sit in the middle of his driveway and I think he can middle of his driveway and do it. That's just my feeling. And I think I made that clear. Here's what troubles me with this bond violation. The subject matter of, I think, this case, at some point, one of the cases, was some flowers or foliage at the end of a driveway. And that led to charges. Now, I'm not going to speak on that, but also what was real clear to me was that there was an issue regarding the driveway. And Mr. Pence being in his driveway. He's not trespassing, he's just in his driveway. When I look at the report, you know, I don't want to say anything that influences what the people do with this case. They've got the report. You guys will do what you're going to do. But I don't know why, knowing that for whatever reason, the driveway is important to Mr. Pence. That, and it doesn't matter what the reason is, it just is. That one would then take and try to place him in a position where he does something by putting something right next to that driveway. It makes no sense. And quite frankly, to then do that, and once he does what, quite frankly, one might suspect he would do, to then call the police and try to file charges against a man in his it's just cruel. It's just cruel. And I am not going to be a part of any of that cruelty. I am not going to find that this is a violation of anything that this court has ordered him to do or not do. He is, if I could say that of his own volition and his own free will that he was failing to follow this court's orders, then certainly anybody that knows me knows I would hold him accountable for that. But he is not intending to violate any order of this court, not show his neighbors or me any disrespect. And I'm going to show him the respect he deserves, and I'm going to find that there's no violation in that report. So the court will not find that there's a violation.
Thank you, Your Honor.
Thank you.
Our new date is January 30th, 2025.
Yes, and his bond will continue.
Thank you, Your Honor.
I'll have an order for the court. Thank you, Judge.
Thank you. Yes, ma'am. Hold on.
Okay. That was the old Mr. Pence update. I don't know. People in that situation, they can become dangerous. There's a whole conversation to be had around that. I agree with the judge when he says that you don't just file people like that away and hide them away from society. And I don't think that's what the purpose of dementia wards or institutions like that are. Those aren't just the filing away of our sick elderly, because the loved ones for those people don't just forget about them, they visit them there. Beyond that, we have a whole lot more show. We still have another hour to go here, ladies and gentlemen. This next one is not a recap. This is not a video that I originally did. I think that the first part of the video is something you may have seen on some other channels. I'm not sure. I don't see everything everybody else does. But this is another case of an older gentleman who's having trouble with his neighbors around him. But it's a very different situation. This gentleman is not suffering dementia. There's none of the heartbreaking, tear-jerking. There's just a whole lot of wow. Ladies and gentlemen, I present to you our next case. I forget this guy's name. Kelly. Mr. Kelly. That's his name.
River Ridge versus Timothy Kelly.
Morning, Your Honor.
My goodness. State your appearances, please.
Rachel Dornbush, Palace Law, 7301 on behalf of plaintiff.
Your name, sir?
I'm Tim Kelly, yes.
All right.
Sorry, Your Honor.
No, not a problem. Ms. Dornbush, you guys can have a seat. Ms. Dornbush, it is indeed a pleasure seeing you actually in person and not in a little box on my screen.
I was telling Mr. Pallets yesterday that my last appearance in your courtroom was the last day we had in-person proceedings before COVID. This Friday, March 13th, 2020, and we were in this courtroom because we had to
Go back and forth.
Yeah.
Amazing.
Yeah, so
It's been a while.
7 months ago.
Yes. Okay, so where are we on this case?
Your Honor, I think today is the date and time for, I think, a settlement conference.
Yes.
As of the last date, Your Honor, given plaintiff an opportunity to file a reply to Mr. Kelly's answer, which got done, setting forth deficiencies in the answer, what I would call admissions in his answer, citing additional grounds on which the plaintiff has to terminate Mr. Kelly. The most serious of which, Your Honor, is based on the revocation of Mr. Kelly's driver's license, which I believe occurred in 2022, and he's certainly been driving his car in the community over the last 2 years, and that violates Michigan statute and the lease and rules and regulations clearly state that a violation of Michigan statute or any other ordinance, local, state, or federal, is grounds for termination of the tenancy. So I don't know that there's a tribal issue in this case, Your Honor. For that reason, we would be asking for a judgment session today.
Mr. Kelly.
I can't hear a word she's saying. I'm sorry, Your Honor. Like 40% hearing, trying to get a hearing aid right now. Appreciate it. Sorry.
Those are different than ours.
Yeah.
Like this?
No.
Like this. Got it. Sorry. That's much better. Thank you.
I was gonna have you do it the other way. Sit here and laugh. Anyway, all right. Could you briefly surmise what you just said, Mr.
Yes, Your Honor.
Sorry.
No worries, Mr. Kelly. Your Honor, as I indicated, concerns that they could file a reply to defendant's answer to our complaint for termination of practice. And in our reply, we did set forth several deficiencies in the answer, as well as the additional grounds on which plaintiff has to terminate Mr. Kelly's tenancy.
The most serious of those additional grounds is based on revocation of Mr. Kelly's driver's license in 2022. Has most certainly over the last 2 years been driving his car in the community, presumably without a driver's license. And the rules and regulations in the community that Mr. Kelly is required to abide do indicate that violation of statute or any ordinance, local, federal, is grounds to terminate defendant's driving in the community without a license, statute, or violation of police agreement. And for that reason, I don't believe there's a tribal fact here. And I do believe plaintiff is entitled to a judgment of possession.
Your response, Mr. Kelly.
Your Honor, none of that was brought up in the initial complaint back in July. So she hasn't brought up one thing that the original complaint stated. So, you know, I don't know where the laws come in as far as my license and everything, but.
Pardon?
I say I don't know where the laws lie as far as I haven't researched anything in the Michigan state statute or the community guidelines that mentions anything about driver's license. That's because this is the first I've been accused of that. I mean, so the first time it was brought up, and that recently happened, and I don't have to own my car anymore. So,
what recently happened?
That my car was taken away or impounded, not impounded, repo. Go ahead, I'm sorry.
I may reply to that. Your Honor, our reply to defendant's answer does set forth the ongoing grounds listed in the original demand for possession, which Mr. Kelly failed to respond to several of those. In his answer, Your Honor, very vague responses to the complaint for possession. 1. 2, Mr. Kelly does not respond to the claims that he was part of the law and that he's been disturbing other residents and that he has verbally abused the threat management and their personnel. He doesn't respond to that at all in the complaint, or in his answer. He makes no statement in support of his claim of retaliatory eviction. The original demand for possession, Your Honor, does state that we would rely on those being specifically delineated, but it also indicates that we would rely on any other violations that he becomes aware of at the time that this demand was issued. Plaintiff was unaware of ongoing issues with Mr. Kelly not having a driver's license. And so now the plaintiff is aware of those, they are going to be relied upon in this case.
I did respond to those as calling them false. I mean, there isn't one statement there. I didn't know if that should have been brought up with my answer or brought up in the trial. Negate those accusations properly. Because they don't stand up to the truth. None of them. So I did state that in the answer.
Your Honor, the Michigan Court Rules MCR 2.111A require a clear and concise answer. The same rule, subsection D, requires the defendant to state the substance of the matter he's going to rely upon in defending the complaint filed against him. 2.111F requires defenses to be pleaded. It also indicates that allegations that aren't addressed are deemed as admitted. Because Mr. Kelly did not specifically, he doesn't make any specific statements at all regarding claims against him. Again, a vague assertion that they're false, but how are they false? There is nothing in his answer to support his claim that these allegations are false.
I did go through each step that they were claiming and disagreed with them. I mean, I thought that's what the answer was supposed to be as far as the state guidelines and the community guidelines. I didn't know I had to choose one. I thought that would be brought up in trial when I could bring evidence.
No, sir. That's not how it works.
If I just answered that these aren't true, each one, yes, I mean, I don't.
Well, you have to specifically lay out what your answer is, not just some general denial of everything.
Well, I don't see anything true about it. It's, it's under the guise of, upon information and belief, which is, it's just hearsay the bottom line. So I didn't, I don't have a lawyer. I can't even afford a lawyer. So I'm trying to do it myself, Your Honor. But all that, I have phone numbers and all kinds of things that you could call if you want to verify my reputation as a decent human being.
When did you stop driving? How long has it been since you haven't driven a vehicle?
I'm getting my license back to the state for quite a while. I don't have any means to get to one.
So you haven't been driving for how long?
It's probably 2017.
So you've not driven a vehicle since that time?
Take the fifth on that.
Okay.
Well, I mean, I got pulled over I went to Bush's. It was for an emergency. I have a daughter at home, stays with me off and on. And as far as that goes,
I got pulled over in Saline. Yeah.
I was driving that day just to go to Bush's.
In August.
To get groceries, yeah.
In August, right?
Yes, in August. I'm a senior citizen on a fixed income, and it's very hard to. Everybody wants lawyers or money, and I just don't have it.
You really haven't stated anything here. You say that they're retaliating. You've not stated anything regarding a retaliatory eviction.
Well, the reason I didn't, Your Honor, was because I thought that would be brought up in trial. I'd be happy to.
No, sir.
Well, okay, I could talk about it now. I mean,
that's not how this works, Mr. Kelly.
What do you want me to go through each one, even though they're false claims? I mean, I don't know how to do anything else except deny that what they're saying is not true. And the retaliation came the day after Miss Smith and I got into a little scuff on the phone. And the next day I have a big thing on my door saying that I'm gonna be evicted. There's false allegations there that I can very easily prove wrong. One, I've never ever threatened an employee or her in any way,
Mr. Kelly,
shape, or fashion.
Mr. Kelly.
Yes.
If I set this for a trial and you lose, you're out in 10 days. You know that.
Out in 10 days anyway, from what I understand.
What?
If I defaulted or you judge for the plaintiff or side with the plaintiff, I thought I only had 10 days anyway. What? Is that true?
Yeah, it's 10 days under the statute.
Well, that's another reason that I feel I have to take it to trial. I mean, my outside of my house is perfect, but the inside needs a little work. And if I was going to sell it, I'd take a huge loss on that. If I had to get out in 10 days, find somewhere to live. I have a dog there. I've been there since 2017, Your Honor. This is the third corporation that's owned it or managed it. I wasn't written up once in those first.
Mr. Kelly, what do you want to do?
I want to.
They don't want you there.
I want to save my house. I want to stay there. I mean, I retired. I put everything I had into that house. I paid my life savings to buy that free and clear so I wouldn't have a mortgage payment. I mean, I was planning on dying in Saline, I mean, there. And it's in a trust. It's in a trust beneficiary, Your Honor, for my daughter. It's the only thing I have to leave for her. She's a disabled minority. She doesn't have anything that's gonna be left to her except that house, and that's my plan, is to leave it to her. And I don't know, between Pamela and I, we used to get along great. I mean, I haven't been able to even speak to her, so I just don't, I'm kind of confused as to, she knows my situation, she knows my daughter. She's fed my dog when my dog comes up. We had a good relationship, and all of a sudden she doesn't even want to talk about it. So I mean, I feel that it's awfully extreme. I mean, I cut the lawn for 4 older women there, and then I have everyone around me.
Mr. Kelly.
I just think I'm not the type of man that they're making me out to be, Your Honor. How else can I come here and
Well, your pleadings are bad, and I could frankly find that I don't have a tribal issue and grant them a judgment today.
Sorry, Your Honor, could you repeat that? I didn't hear you, I'm sorry.
Your pleadings and your filings are bad. They're missing all kinds of things. It doesn't present to me an issue that I could even try at this point.
Well, I can't even keep up with the paperwork between the the monetary things that I get every month. I mean, I've been going to court. I've been before you for the last 6 months. I mean, it's hard to keep up with all their paperwork. I apologize, but I didn't know that. I can't afford a lawyer. I'm trying to do the best I can. I thought that I could, I can bring you evidence of negating some of that stuff in trial. I didn't, if you want me to answer that and give you
I told you to answer before, and I don't have it. Actually, I told you, I think, twice.
Well, you do have it, Your Honor, because you found it at the last hearing. We took a recess because you didn't have it, but then the court clerk.
That's not what I'm talking about.
Oh, I'm sorry.
Your answer is wholly deficient.
Okay, I apologize. I was up all night. I don't know, really. I'm not an attorney, so I thought by just telling you that, I don't know how to answer. Some of those aren't accurate to the facts, so I didn't know if you wanted me to just state without any evidence to negate their claims. I didn't think you needed me to just say, what went on there, because I couldn't bring you any proof of it. So I didn't know that. I can present evidence and all of that if you give me time.
What would you present to this court, Mr. Kelly?
Well, I could present the fact that the claims that they filed are false. For instance, the car on the lawn, the threatening of the employees. I don't have all of them in front of me, but I could prove that those aren't true. And there's been other write-ups that through the.
Suppose you have a photo.
I have a photo. It's his mother-in-law's car. It was towed last year after many months and notices that the car needed to be removed. My understanding, Mr. Kelly, please let me finish, is that when the tow company came out to remove it, he threatened the tow company. Now, I'm still trying
That's
to.
a lie. That is a lie, and I can prove it wrong because I spoke to the Mayflower towing guy, and he denied that he ever said that. In fact, Ms. Smith said that he told her that he told her that I pulled the gun on him. Yeah, what is this? The car? I'm not denying the car. I'm denying that the fact what they said.
Mr. Kelly, you just
gave me permission, Your Honor, for that car to be on the grass. She knew that it was my ex-wife's mother's car, and she just passed away, and she didn't have anywhere to put it. And I had it on my driveway, leaking a little oil, so I just moved it. Now I repaired that lawn, and it's a beautiful looking car. If you saw it, but she was aware of it. Now, there was some controversy the day that it got towed, because I was asking her to please wait because my ex had called me and she called.
If she gave you permission, why would they have it towed?
Because it took.
Why would they have it towed?
Because
If what you said, Mr. Kelly, if it's true, that they gave you permission to have it there, why would they have it towed?
It was, Your Honor, I could prove that it was.
It does answer my question.
It was towed because it had come to the point where it was on the lawn, it was there too long. And she said that she stamped the car was there for a year, Your Honor, on that lawn for a year. And then she put a tag on the car, and that's when we started negotiating, and I called my ex and told her, you got to get this car out of here. They want it out and it's going to be towed. That was when it came to that point.
Mr. Kelly.
But it was on the lawn
Mr. Kelly.
a year, Your Honor.
Mr. Kelly.
Yes.
You told me 3 different things about this car. You're telling me that they gave you permission to have it on there.
Yes.
So how long, presuming they gave you permission, how long were they allowing you to keep it on the property?
There wasn't any set time. It was there. I kept the lawn. I always whipped around the car. I cut the lawn. When the car was
I
gone,
didn't ask you about the lawn.
I repaired the lawn.
I didn't ask you about the lawn.
There wasn't anything in writing or set. It just came to the point where it was there too long. Like I said, Pam and I got along fine. And then it was getting to the point, look, that car has been on there, or the car has been sitting there for too long. It didn't have proper plates. And that's when they put a tag on it, and they gave me 10 days to get it out of there.
And did you?
I was my ex-wife. Yes, she was in the process of getting it. And I was on. I had no.
You talk in so many circles, Mr. Kelly.
I'm not talking in circles.
You absolutely are.
You're asking me what happened, and I'm telling you.
I didn't ask you what happened. I'm asking very specific questions, and you're not answering.
I'm telling you.
You take off going in another direction.
I didn't have anywhere to put.
Why do I care whether you weed whipped around the car?
I guess you don't.
I don't. I didn't ask you that.
Well, they're making it out like my property's a junk pile, and it isn't. It's one of the nicest kept up yards in the area.
Did I ask you that?
I'm sorry.
First off, there's nothing in any of our pleadings in any way, shape, or form alleging that his site looks like a junk pile. So no, that is absolutely false. Your Honor, I have here a rule violation issued December 30th, 2022, no parking on the lawn. A rule violation issued on January 12th, 2023, no parking on the lawn. There is a note that they also emailed him about the dog being outside on tie-out, also a violation of the rules and regulations, and the vehicle being on the lawn. On 2/1, he called and said he will remove the car within 1 week. On 2/16, the car was tagged. I don't know the exact date that it was towed offhand, Your Honor, but what day was it? April 23rd, Your Honor. So many months after all of this. So Mr. Kelly had ample time to remove the car, and he didn't.
My ex was speaking with Ms. Smith, and it was kind of between them at that point.
No.
I'm talking about the last. You can ask her. My ex talked to her. They were
Mr. Kelly.
They were talking
Mr.
back
Kelly.
and forth. Her mother died here.
Mr. Kelly.
Yes.
They told you to get the car off the lawn. They told you you were in violation.
And I did.
You did nothing.
I did get it. It was towed.
Who towed it?
Mayflower Towing.
Okay.
At that point, I said,
bad question.
I said,
You want to know what?
I was trying to save
This
my
is why
ex some money.
Mr. Kelly,
Yes.
you're never going to overtalk me.
I'm not trying.
No, you are.
It just seems like just a man trying to save my house, Your Honor.
Mr. Kelly, you told me about that vehicle. I just take that. What they told me is what Ms. Dornbush laid out. You weren't telling me the truth.
I am telling you the truth.
No, you're not. Why would she give you permission to park on the lawn and then send you a notice that you're in violation?
Because Honor, I can give you proof of when the car was there and when it was towed.
Listen to my question. Listen to my question.
Go ahead.
Oh, no. Mr. Kelly, you better check that attitude right now. You better check it.
I'm not trying.
You better check it, Mr. Kelly. Oh, don't. Oh,
I don't know
Oh,
what
no.
I'm doing wrong. Your Honor.
Here's one thing that you've done wrong.
Please tell me.
Here's one thing that you've done wrong.
What?
I am not gonna have that attitude coming from
I
you.
don't.
You need to figure out what you're doing. You have interrupted me throughout these entire proceedings. I'm not gonna have it. Outside of the fact you've got a warrant for your arrest.
I apologize. Your Honor.
You got a warrant.
I didn't know that.
Yeah, it's from the driving while license suspended.
I didn't.
So here's what we're gonna do.
Sorry.
Just so happens the judge that's in front of is next door. But right now, you're gonna go into custody. We're gonna take you in. I'm gonna go next door, talk to Judge Freshour, see what she wants me to do with you.
Please, Your Honor, I have a gun. I need to wait.
What did I just say?
I just checked with the court about a warrant.
Court's gonna stand in brief recess. I'll be right back. Kelly. River Ridge versus Kelly. I had to check with Judge Freshour. We will be releasing Mr. Kelly not until 1 o'clock today. I'm not going to hold you guys here. What I will do is I'll set this, Ms. Dornbush, if you're available for a non-jury trial on the 30th. Will that work?
There might be something going on.
Just doing that so you have to come back and see us.
Your Honor, we don't mind coming back at 1 if Your Honor wants to do that, but I mean, if it's for the purpose of doing a bench trial, we don't have all of our witnesses that.
Right, and I think I'm gonna do a bench trial, let him bring what he wants in and do that.
Get our witnesses
All
together.
right.
So the,
October 30th, 2024 at 9. Okay, thank you. Sorry about the wait. We were trying to. What else? Oh. I see the show up. Hi. Can we hold that for this afternoon? Because the printout is in there for Mr. Kelly. Okay, you guys have a great day. Yes, take care. She'll be back on Friday in the little box again. That's it. Check the lobby and everything. 14A District Court is now back in session. Court does call the case, River Ridge versus Timothy Kelly.
good morning, Your Honor, Rachel Dornbush, Pallets Law, P 78301 on behalf of the plaintiff.
Kelly is not here. We have checked the hallway all the way down to the lobby and he's not here. This date and time set for trial how would you like to proceed?
Your Honor, in light of his failure to appear, may I be sworn?
Yes. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do. Again, for the record, Your Honor, Rachel Dornbush, Palace Law, on behalf of the plaintiff. Your Honor, this is the date and time set for a bench trial in plaintiff's action to terminate defendant's tenancy in the community. Your Honor, as you can see, we have a courtroom full of witnesses here prepared to testify in support of plaintiff's case. Based on defendant's failure to appear, we are requesting entry of a default possession only judgment with a writ to issue after November 11th. Your Honor, this action is based on Mr. Kelly's violations of the lease agreement, community rules and regulations, which include threatening, harassing behavior towards management, harassing behavior towards other residents, not maintaining utilities in his home, violating Michigan law by driving his car without a license in the community, keeping his dog outside unattended on a tie-out, and other various violations, Your Honor. I do have to present to the court a proposed judgment of possession that does require Mr. Kelly to cease residing in the home by November 11th. It does, Your Honor, provide Mr. Kelly 90 days to sell or remove the manufactured home subject to certain conditions under MCL 6005781, which is listed on the back of that judgment, Your Honor, as Mr. Kelly owns his manufactured home. A few things to note, though, Your Honor, there is some money in escrow. We would be requesting that those funds be released plaintiff. Your Honor, the Michigan Mobile Home Commission Act, and I may have to pull my phone out so I can cite the specific statute for Your Honor, does indicate that in an action to terminate tenancy, the prevailing party is entitled to liquidated damages. And in this type of action, Your Honor, those liquidated damages are $500. So we would be requesting that the court award those liquidated damages and giving plaintiff authority to assess those liquidated damages to his ledger immediately after giving a 7-day notice that those charges will be assessed to him if not paid. Finally, Your Honor, plaintiff is entitled as well to statutory court costs. Those amounts are $174. So we would be requesting not only the $500 in liquidated damages, but the statutory court costs of $174 as well. Your Honor, the statute at issue is MCL 125.2328C, which indicates in an action to terminate tenancy for just cause, the prevailing party is entitled to those liquidated damages of $500 in an action in the district court. Also, there's a provision for $300 at the appellate division, but the $500 amount would apply in this matter. Finally, Your Honor, we do have a couple of concerns regarding Mr. Kelly's presence in the community. We have a number of witnesses here prepared to testify of their, number one, fear of his presence in the community, but also their fear of retaliation. They were concerned about their testimony here today. And if Mr. Kelly had appeared and been witness to their testimony, we were intending to ask the court to enter an order requiring Mr. Kelly to refrain from any contact with the witnesses that were here today out of their concern that he may retaliate based on their testimony. I know Mr. Kelly's not here to witness their presence, but I know that the court is recording this session.
Yeah.
And I would still request that the court make that order, as there is a concern that he may act out based on the ruling here today.
Here's what I'll do. I will sign an order to that effect. If you prepare one, send one to the court, I will sign it. That way that will give him notice. If he wishes to challenge the court's issuance of the order or the court's authority to issue such order, then he may do so.
We'll do it under the 7-day rule.
Notice.
Yeah. And the last thing, Your Honor, is after the last of Mr. Kelly's personal property is disposed of in the community, which presumably will be the manufactured home itself, the community is asking that he be deemed a trespasser in the community. It is a privately run community, private property, and based on his behavior in the community and the threats that he has made to management, and again, I have manager here prepared to offer testimony if Your Honor needs it, that once he no longer owns personal property in the community, that he be deemed a trespasser and not allowed to enter River Ridge at that point.
I think well, for purposes of any type of landlord-tenant proceeding, I don't think I could consider him a trespasser because he came in under color of right. However, if he does enter the premises, and I think actually pursuant to the criminal statutes, you could send notice somehow to him of that he is not welcome on the premises. That way, then if he comes on the premises, the criminal statute is complied with by being told that he cannot appear on the property. And then if he enters the property, he would be deemed a trespasser.
Would the court allow me to include that language in the order I'm submitting under the 7-day rule? Because that would serve as notice to him that following disposition and removal of his property from the community, he is not allowed to access the community.
Yes, you can include that in there.
I will do that then.
And I'm letting you include that. I'm not in including that. I'm not making a statement as to whether or not that would be sufficient notice for a criminal trespass case.
Understood.
That would be up to the prosecutor. How much, what were the costs you were claiming?
174, Your Honor.
Thank you. So what I've done is I have indicated the escrow will be released to plaintiff, and plaintiff is entitled to $500 liquidated damages, cost of $174, and that is awarded to the plaintiff. And so I place that under paragraph 10. I have also made a change at the order of eviction being the 12th because the 11th is a holiday.
Understood, Your Honor.
So, and thank you for that. And I've signed the judge.
Thank you.
Thank you. Thank you folks for all coming down. Appreciate it.
Thank you.
That's it for us for today.
Oh my God, but it's going so quickly. Jeez. I can't believe this. So, that leaves one set left. Ladies and gentlemen, this next set is from Simpson on the 31st. This is a potpourri set, so you're going to see a lot of different people coming and going. I chose some of the more flavorful characters. I kind of did a hot jump around, but towards the end of this set, there's a special appearance from two of our favorites and a little bit of a recap from one of my favorite appearances that we've seen over the last year. A lady I call Rosebud for reasons. Her name is I forget her name. It doesn't even really matter. If you know who Rosebud is. No, it's not Bloom, it's not Shoe. It's Northwest, you know her. You know her. The girl who made out with her victim during court. It was her. She shows back up. Her name is like right here on my head. So we got one set of Simpson left, ladies and gentlemen. It's been a great show. Thank you for hanging out with me. I'll see you again after this set to say good evening or good day. And we'll talk about the rest of the stuff in the comments after that. Let's watch one more set of Simpson together.
Court calls case People versus Ryan. Is it Deacus?
Prosecuting attorney on behalf of people, and this is the public defender Shanazai Kiri. I can really, on behalf of Mr. Ryan Dykus, who's approaching, Your Honor. I'm right here. Ryan, could you state your name for the record, please?
Ryan Dykus.
Your Honor, today's the date and time set for probable cause conference. We would respectfully request that this matter be set for preliminary examination, and we'd also like to address bond, Your Honor.
Discovery is complete.
To our knowledge, Judge.
People have their witnesses available the 12th.
We'll do our best.
Probable or preliminary examination will be set November 12th, 2024, 9 a.m. in person before Judge Burke. Quickly, Esteban.
Your Honor, we are asking that my client be released. Mr. Dykus has been suffering from some significant health issues. We do understand that there are a few holds in the system. He indicated that those holds have been there for some time. He was in Oakland County before he was released to Washtenaw County, and Washtenaw picked him up. But my understanding from him, Your Honor, is that the other holds or counties did not. There is a bond denied out of Wayne County. He says that that is based on his probation. It's just a probation violation. He knows that once he reaches there, they are aware of the situation. They just want to book him and release him. He suffered from a TBI in 2020. He has now been developing new stroke-like symptoms. He indicated that he had a stroke while he was in Oakland County. He's had, I don't know if they're mini strokes or more stroke-like symptoms while he has been here. There was significant follow-up that was required by the doctor when he suffered the stroke in Oakland County. He has not been able to do any of that follow-up. That was about 2 weeks ago. He's still complaining of numbness and tingling and some other neurological issues while here. He really wants to get that matter taken care of, or at least he's okay with the GPS tether if the court wants to do that to make sure that they know where he is. I know the issue with multiple holds and how individuals can get lost in the system, but we do believe that his health issues may be much more prevalent than what we know of.
Response.
So he has 6 holds, one out of Dearborn City, which is $250, current traffic hold, an MSP Metro South hold, Harper Woods PD for $570, and then 2 holds out of Wayne County. He was on probation for fleeing third and larceny from a firearm out of Wayne County when this conduct occurred in December of 2023. He has an extensive history, including 3 convictions for felony firearm, conviction for armed robbery, conviction for felonious assault with intent to rob while unarmed, which was a conviction for fleeing third, and then 2 convictions for larceny with firearms. This is a strangulation with multiple accounts hanging underneath this strangulation. I'm extremely concerned. I understand health issues, but I don't think any reduction at this point is appropriate, given the fact that we requested a $100,000 bond and he was given $50,000.
And Your Honor, just very briefly, I do want the court to understand the date of this offense is from 2023, Your Honor. He has not had any issues.
Was he on probation at the time that this allegedly occurred?
Based on what I'm looking in the.
Motion for bond reduction denied.
Thank you.
Bond will continue. Court calls case People versus Demetrius Caldwell.
Morning, Mayor. Please, this Honorable Court, Kareem Johnson, on behalf of Demetrius Caldwell, stands to my immediate right.
Sir, state your name.
Demetrius Caldwell.
Questioning and adjournment.
Yes, Your Honor. We requested adjournment. I was appointed on Tuesday. I have not received discovery yet. Also, after speaking with the APA assigned to the matter, I believe my client is under a competency review in another matter. I do not have the case number or aware of that case.
All right. Probable cause conference, November 14th, 2024, 9 a.m.
Your Honor, may I address my client's bond?
You may briefly.
Your Honor, my client does indicate he does have a location he can go to. His brother Jalen, 701 Miller, Ann Arbor. He was working at Happy's Pizza when he was arrested. Graduated high school, Wayne Memorial, lifelong Michigan resident, and is under a care of a guardian. He has been removed from the location in which these allegations arise. I don't believe anybody was physically hurt. I do not believe that he's a flight risk or danger to the community at large. Ask the court to grant a personal bond.
Response.
Could you please tell me what the bond is currently set at?
$2,500 cash surety.
We asked the court to continue that bond. We had originally requested $25,000 cash or surety. I got significant consideration for the situation and things that are going on with him. This case, unfortunately, did involve allegations of threats of violence and people are concerned, especially with competency. Yes, the court continued the bond is currently set by that it was a use of discretion.
Do the people know where the other competency case is?
I don't have that information right this moment, Your Honor.
All right. Well, until I get some information on that, I'm not inclined to change his bond. Motion for bond reduction denied. Bonds will continue.
Yes, Your Honor. Thank you.
You know what I'm gonna say? Huh? All right, stop talking to me. Okay, all right, fine. Court calls the case People versus Aquila Burks.
No, you come back.
Good morning, Your Honor. Tina Saxon on behalf of Aquila Burks, who's standing to my right. Ms. Burks, state your name for the court. Aquila Burks.
Thank you. You're requesting an adjournment for discovery.
Yes.
Probable cause conference November 14th, 2024, 9 a.m. Bond continued. Thank you.
Thank you.
Court calls case People versus Edward Graboszewski. I said. I did. No, I didn't.
You're right.
Why are you correcting me? Why are you correcting me? You get a new last name and now you're correcting people. Mr. Feaster, did I call it correctly?
I think you did, Jeff.
Yes, thank you.
Torshell Feaster, Assistant Public Defender, appearing on behalf of my client. Please state your name for the record, sir.
Robert Droboszewski. Good morning.
Exactly what I said.
Thank you, Judge. My intern had a long conversation with my client. It sounds like there are several things he has some questions about, including he wants our office to interview the alleged victim in the case, and he wants us to go through with him what would happen with the competency situation that he has, I guess, refused up until this point. So if we could have maybe a 2-week adjournment, I'll sit down with him, go through all these questions, make sure he has all the answers, and have my investigator go and meet with the person he wants us to meet with and look into the bond situation that he has questions about. Was that correct?
Yes, sir.
Okay.
All right. Will 2 weeks be enough?
Yes, sir. You shouldn't
Get
take
that
it
done?
long.
Thank you, Your Honor.
November 14th, 2024, 9 a.m.
Thank you.
Thank you.
So
Bond continued.
Monday or Friday, you can always call the attorney's office. And
I won't call. I'll wait for you.
I'll come see you.
All right. I appreciate it.
Yes, sir.
Thank you.
Take care.
Court calls the case People versus Alina Bustle.
Ashley Lundy for people.
Morning, Your Honor. Marcia, on behalf of Ms. Fussell, who is approaching. Ms. Fussell, can you please state your name?
Alina Russell.
Thank you.
This will be a waiver, Your Honor.
Ma'am, is that correct? You're waiving your right to a preliminary examination?
Yes.
You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes.
You understand you'll not have that hearing and that you'll proceed to circuit court for further resolution.
Yes.
People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on all 3 counts.
As to the arraignment, Your Honor, we acknowledge receipt of the information, waive its reading, and ask the court to allow my client to stay on mute.
She doesn't say anything, then she's done it. Defendant every way forward reading, standing mute. Court will enter a not guilty plea. Pretrial in this matter will be set for
December 23rd at 1:30 before Judge Slade Monday.
December 23rd, 2024, 1:30, Slay Monday.
Thank you, Your Honor.
Bond continued.
December. Thank you.
Who? The one in pink?
Yeah.
Can you get the lady in the pink, please?
That just left out.
Yeah, it just walked out. Court does call the case of the People versus. Do you have a copy of it? Court Court calls the case People versus Deshaun Glover. That's her. Good. That's her. What you gonna learn? Okay, thank you.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Glover. Your Honor, he's in custody.
I know.
Morning, Your Honor. Attorney Quentin Dox. I just been retained on Mr. Glover's case.
Okay, I don't have a substitution. Did you send us a substitution?
I had to send it to the Washington County Defender's Office, Your Honor, so they could sign off on it. And then, so I didn't send it to you directly.
Have you seen it?
No, Your Honor.
Okay, well, somebody needs to get that to me.
If you want to email it
Her
to me,
office had-
I can.
Okay, somebody, you guys do something. I'll call him out, but I don't have anything. I have the PD on the case, folks.
You're bringing Mr. Glover now.
Well, no, because I don't know who his attorney is. You hold Glover, because you guys get the paperwork in order. I'll call the case up. You can take him back.
Yes, Your Honor.
Glover, the one that. This is what check is referring to. But I don't know where she is.
She's
Okay.
over here. What's it on?
14, she actually just recently failed to appear.
What?
Maybe she failed to appear.
Good, okay, all right.
Yeah.
Well, let's call the case People versus Alina Bustle. Recall.
Ashley Lonnie for the people.
Good morning, Your Honor. Marcia Creech on behalf of Ms. Bustle. Ms. Bustle. State your name. Nina Bustle.
All right, Ms. Bustle, I was informed you have a warrant out of 14-2 on two, or at least one, I think, resisting and obstructing charges.
Okay. It was for an R&O? I mean,
Well, it was reduced to attempted, I think. But she didn't appear.
okay.
And she currently has a bond in that case of 10,000 with a 10% privilege on it.
Okay.
That she hasn't appeared. And she has this case also here pending, which also involves resisting and obstructing.
Well, clearly I was unaware of that. I would have had to take care of that, Your Honor. She had shown,
I would note that the PD represents her on the 14-2 matter.
Yeah, may I have that case number?
Certainly, it is 23-2-0143.
can you repeat? Is that 22 actually?
Yeah.
Your Honor, and prosecutor. Your Honor, I would ask the court to allow Ms. Bustle to go walk in on the warrant or do what is necessary. She has shown up for every court date here. She had,
Go ahead.
she has, and been in contact with my office and been very cooperative. I know I'm not the attorney of record on that matter, but I would be asking for that.
Well, what they can do is they can try to figure it out. They can contact Judge Barr's court and do that. But at this point, she didn't appear on that case. She's taken her into custody. Defendant's remanded on the warrant.
Thank you, Your Honor. Don't forget.
Court does call the case. People versus Tanya Putman. Oh, dear.
Good morning, Your Honor. Sydney Rushing appearing on behalf of Ms. Putman, who appears to my right. Restate your name for the record, please.
Tanya Putman.
Yeah, a little bit louder.
Tanya Putman.
Thank you.
Who's on the Putman matter?
Sorry, Your Honor. What's the name?
Putman.
Thank you. Ashley Lonnie for the people.
Your Honor, today is the date time set for a probable cause conference. At this time,
It is.
we're
That's what they're
requesting-
all set for. Go ahead.
Yes, Your Honor. We're requesting a preliminary examination in this matter.
Is all discovery complete?
Yes, Your Honor.
People have their witnesses available to 12.
We will try, Your Honor. Thank you.
Preliminary examination in person, November 12th, 2024, 9 a.m. That is before Judge Burke. Oh, I got you. Before Judge Burke. Bond continued.
Thank you so much, Your Honor.
Thank you. Case of the people versus Melissa Milliken.
Good morning, Your Honor. Nicholas Trudell on behalf of Ms. Milliken. I substituted in for the PT this morning. Thank you to the court and the staff for accommodating my late appearance.
Oh, not a problem. Was this the one that was set at 1?
Yes,
It's set at 1 o'clock. And then Mr. Romel was requesting to be seen this morning in the midst of my busiest part of the docket. Yeah. And the record should reflect that was really nice and I granted that. Right?
Yep.
Yeah, I did? Oh, okay. I just was trying to get everything clear.
I acknowledge the record so reflects your.
All right. And good to see you, Mr. Romel, and you're requesting an adjournment.
Yes, we are, Your Honor. And if I could briefly address a bond condition. Ms. Milliken is here with her friend, Mr. Damon Mark, and they have a prepaid trip planned to Texas in August or November 8th through 16th. And
for why?
It's Mike Tyson boxing match with some other boxers.
No.
It's
no, I'm kidding.
Apparently,
I'm sorry.
It's Mike Tyson, Jake Paul, Amanda Serrano, and Katie Taylor. It's going to be amazing.
Oh.
So we're requesting.
That could only take place in Texas.
It was rescheduled.
So we're requesting permission that she'd be able to go out of state for that.
Okay, well, first of all, how much time did you need on an adjournment?
Probably not a lot, but I'm going to be in Grand Rapids for depositions next week. So it's just.
I got the 14th, 21st, or 26th.
Well, 14th is when she's gone of November. 23rd was a date.
Well, no, 21st.
Thursday, the 21st, I have a deposition, and the 26th was another date.
That was the other day.
I could do that one.
All right.
You could do that one, November 26th.
Ms. Weiling, exceedingly nice. Right? Thank you. November 26th, 2024. That in the morning, right?
Yeah.
That's at 9 a.m.
9 a.m.
Yes, that's my split docket. So that one will be in the morning part of the docket.
Get copies of the notice.
Okay.
Bond will continue. You want to travel what dates for this festival thing?
12th through the 18th. 12th through the 18th of November.
6 days to box? Fine. Defendant may travel.
You got to, you got to do the whole atmosphere, the box skating. I don't know what they do.
Texas, what days again?
12 through 18.
November 12th through the 18th, inclusive. Good luck. Godspeed to you. Good.
Okay.
I don't have an attorney. Thank you.
Oh, thank you.
Thank you.
I didn't think he still box. Whatever. Court calls case People versus Stephen Hensel.
Read in this matter, Your Honor. Juan Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Hensel. Mr. Hensel, state your name.
Stephen James Hensel.
Your Honor, as the court in receipt of a competency
report, yes, I am.
Your Honor, we have no further evidence to present.
Any other evidence from the people?
There are basically the addition of the report.
All right. court upon a review of that report would find that the defendant is indeed competent to stand trial, would specifically find that the defendant can understand the nature and objects of the proceedings against him.
Something I'd like to state if I could.
And can rationally assist in his defense.
I prefer to.
Therefore, the defendant is deemed competent. The court has signed the order.
Thank you.
I would like to state something. It's been difficult for me to contact my attorney. Upon my admission, I was not given a rule book. It wasn't until day 19 when I received.
What rule book? I'm sorry.
It's the Washtenaw County Jail Rules and Regulations.
Okay.
That was given to me on day 19 when I received a tablet. Now, I had requested a tablet on the 7th, did not receive one until the 19th. And that was the first time I had access to the rule book. In the section of telephones, item number 2, it says each incarcerated individual is allowed the opportunity to contact counsel. That was not the case. It says, note, the telephone number to the public defender's office is posted in each housing unit. That's still not the case. So I was unable to contact my legal support. I feel as though I'm not able to, even this week, I tried to reach out to the public defender's office to talk to them about what was going on today, and I haven't been able to speak to my attorney. It's basically, I feel extremely misunderstood, and there's a lot of things like that going on. I mean, this competency hearing prevented me from talking to my legal support for nearly a month, and it's just been super problematic for me because despite me having, I'd like to give my side of the story, but I wasn't able to up until the 12th. To demonstrate how bad it is, I spent the first 14 days trying to contact my parents on the phone system. And it wasn't until day 14 or so, 2 weeks, that I was able to reach them. This was after my first hearing. So it's just, and the nature of the situation is I haven't been able to contact legal representation. I've been severely misunderstood, and I haven't been able to represent myself up until continuing to this point.
So, Your Honor, now that the competency matter is past us, he'll absolutely have an opportunity to speak to counsel. They'll be able to review the discovery with them and go over the reports. He'll have an opportunity to do all of that.
Set this for a probable cause conference. November 14th, 2024, 9 a.m. Bond continued.
Thank you.
Thank you. Yes. Court does call the case, People versus Dolores Strickland. Court calls the case, People versus Dolores Strickland.
Ready,
Bill
Judge.
Kirby on behalf of the people.
Court shall cease to assistant public defender on behalf of Miss Dolores Strickland. Miss Strickland, please state your name for the record. She had been here.
He is here, but not in the camera.
And Your Honor, can we briefly approach?
Seriously. Yes. You knew it was going to happen. All right. We all set? That's it? Okay. And so, folks, court will stand in recess. We will reconvene approximately 1 o'clock. To call the rest of the cases. Court's in recess.
Like pillows and
I think I'm back. Are they back?
Yeah.
All right, on this matter, record should reflect you've had a brief bench conference. Miss Kirby.
Your Honor, during the break while the court was taking an hour recess in between cases, it appears that the defendant and the victim were on screen, obviously violating the no contact order. They were doing non-appropriate courtroom things, and the people are asking, giving the violation in the court and the violation from community corrections as well, that the defendant's bond be revoked and she report to the jail by this evening. If not, I would ask for an immediate bench warrant to go out. I know there's a bench warrant already with no bond out of community corrections.
Ready, Judge?
Good morning, I'm Rita, Assistant Attorney for the people.
Court shall feaster Assistant Public Defender appearing on behalf of Miss Dolores Strickland. Ms. Strickland, please state your name for the record.
Dolores Strickland.
Your Honor, we have been here several times. Ms. Strickland and I have finally spoken and seen eye to eye, and we are now prepared to do a waiver to circuit court.
On all of the cases?
Yes, Judge, she'll be doing a plea at circuit courts. Waive them all.
Ms. Strickland, is that correct?
Yes, sir.
Now, you understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes.
Yes?
Yeah.
All right. You understand in all three of these matters that you'll not have that hearing and that you'll proceed to circuit court for further resolution.
Yes, sir.
People also waive their right.
Judge, could I put the offer on the table?
Sure, go ahead.
Thank you, Judge. The offer that we have is Ms. Strickland will be pleading guilty to child abuse third degree and malicious destruction of property and agreeing to full restitution. The remainder of the cases and charges would all be dismissed upon completion of a successful plea at court, Your Honor.
Is that a correct?
For the record, I'm sorry. That's my one thing. With an agreement to full restitution, that would include any dismissed counts.
That's correct, Your Honor.
All right.
I'm just putting on the record what you and I discussed. I know that.
What did you say?
She says the rest of it. You have to pay for the damages that we talked about on the phone to the police, yes. Okay? You understand?
Yeah.
Okay. Thank you, Judge.
Judge, all set.
Yes, Judge.
Preliminary examination having been waived in the case ending in 5173, defendants bound over circuit court on counts 1 and 2 with 3 following. On the case ending in 5063, she's bound over on all 4 counts. And on the other matter, she's bound over on count 1 with 2 following.
Thank you,
Mr.
Judge. We will stand mute and wait for a reading, Your Honor.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea as to all charges. Pretrial in these matters will be set for
November 13th at 1:30 before Judge Conlon.
November 13th, 2024, 1:30 before Judge Conlon.
Thank you very much, Judge.
And may I approach the defendant?
Yes, let me just tidy this up here and then. Court does call the case of the People versus Christopher Page.
Assistant Public Defender Natalie Pate on behalf of Mr. Page, who.
Hold on one moment, I don't have a camera.
And Your Honor, I'm sitting back there right now.
Oh, okay, sir. I'm sorry, thank you.
Give us 30 seconds here.
Yes, sir.
Page, can you see him, Your Honor?
Pardon?
Can you see him?
I cannot see him. Yeah, just a little bit lower. There he is. Mr. Page?
Yes, sir.
Can you state your name for me?
Christopher Page.
All right. This is going to be a waiver.
Yes, Your Honor. I have been able to meet with Mr. Page and discuss this matter with him. He wishes to waive his right to a preliminary examination in this matter.
All right. Is that correct, Mr. Page? You wish to waive your right to a preliminary examination?
Yeah, I wish to waive my right, but I was wondering, can I get a bond release, bond hold?
Well, those are two independent things, but I need you to understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it. You understand that?
Right.
All right. All right. You understand that you will not have that hearing and that you'll proceed to circuit court for further resolution in this matter. You understand that?
Yes, sir.
All right. People also waive their right.
Yes, sir, I think so.
Preliminary examination having been waived, defendant is bound over to circuit court on a single count.
We acknowledge receipt of the information, waive for further reading. My client stands mute.
Defendant having waived formal reading, standing mute, the court will enter a not guilty plea. Pretrial will be set for
November 18th at 1:30 before Judge Slade Monday.
November 18th, 2024, 1:30, Slay Monday. And were you raising anything else?
No, Your Honor, Mr. Page is currently being held on another matter of violation of probation where his bond is denied. His bond in this case is $5,010%. So I would request that it stay the same considering he's being held without bond on his other matter or bond being denied.
Okay, so you're being held on something else. All right. In this matter, then defendant. I'm sorry?
But get a bond, for a minute.
Well, the bond on the other case has to be set. The bond on this case is a reasonable bond. So it's the other matter that's really holding you.
What's the bond on this case?
Bond on this case is a $5,010%, but that's so that you just get credit because the other one is holding you. You're not going to go anywhere. That one's not before me today. Okay, thank you.
Thank you.
Thank you, Your Honor. Thank you, Mr. Page.
Court does call the case of the People versus Cody Jolly. Is there? Mr. Jolly? Mr. Jolly, are you there? Did you want to participate in your probable cause conference, sir?
He said he did not.
He did not?
He does not want to participate, no.
Okay, thank you.
Thank you,
Defendant
sir.
being he's refusing to participate, I will adjourn this matter then to November 26, 2024, 9 a.m. Bond continued. What time do we go back on? 1 o'clock? We got an hour? I've told you about that. What's going to end up happening is I'm going to end up running off. I won't be back at 1. I'll stroll back in sometime this afternoon. Okay? No. If I get let loose from here, I'm gone. Just letting you know.
Ladies and gentlemen, this is it. That's all we got. It's been a long show today. Started this at 11 o'clock my time. Now it's almost 1:30. We had a lot to cover. Those were a lot of interesting updates. I enjoyed every minute of it. Thank you everybody for hanging out. That was amazing. Comments were amazing. Chat was amazing. I don't even know what else to say. It's Saturday. I think we all have stuff we need to do. I definitely have things I need to do. Not things I necessarily want to do, but things I need to do. That's what's going on. So anyway, I do these things every Saturday at 11 a.m. Central Time. That's 12 p.m. Eastern Time. And if you want to see more live stuff like this on this channel, then you can come by every weeknight at 8 p.m. Central Time. That would be 9 p.m. Eastern Time. And we do the Fleischer Forum every weeknight that Fleischer has a docket to be watched. It's just a place where we all get together and watch what he did during the day and comment on the things we see that we feel like we want to comment on. That's what we do, like, as court watchers. Right? Right. Well, ladies and gentlemen, I've had a good time today. And I really thank everybody for coming out and hanging out with me. It's always a fun time. I will be having a Manic Monday video on Monday, but it is going to be a premiere. So if you want to come by, check out Manic Monday and still chat about it, we're still doing that. We're still doing that Manic Monday thing. It's just going to be an hour-long premiere that actually, if things go right, if Comcast doesn't go crazy on us, it should just direct right into the live stream. So if you come to Manic Monday, you should redirect right into the live stream after the fact. I'll look forward to seeing everybody during the week on the live streams, and keep an eye out for my standalone videos that I do and throw out all week long also. Ladies and gentlemen, I'm your Lone Wolf Usul. I'm your curator for these videos, and I do thank you for your patronage. I love you all very much, and I'll see you next time. I'm out of here.